have some right.
Absolutely, Your Honor.
But so haven't they given some consideration for agreeing not to require that the equipment be turned over?
Well,
Why doesn't that create a binding agreement?
it does, Your Honor. I mean, we've never, that's the difference between lack of consideration and failure of consideration.
And I guess the question is, why doesn't that survive the subsequent sale?
Because at the time of the subsequent sale, there is no longer any quid pro quo. There's no forbearance to exercise because there's nothing from which to forbear. And on the other hand, by the time at the point that happens, Integrated is out of pocket $350,000 that it spent to acquire the whole bundle of collateral, not just these two items, but the whole bundle of collateral from VMC. That's why this case isn't controlled by the Turner versus Clayton School District case, because there's more that was given. There was more expense on the part of the, in this case, the party in possession.
The problem, I'll tell you the problem that I see with your position is all that is well and good regarding Sovereign. The problem is that Integrated signed an agreement with, signed a forbearance agreement that said if VMC doesn't perform, then we are either going to return the property or pay you damages.
Well,
Now, granted, they can no longer return the property because they own it from another sale, but that agreement still requires, in the event of a breach by VMC, still requires Integrated to pay the damages. They put themselves on the hook. They were like a guarantor. And that's the problem I'm having with your argument. It's the fact that Sovereign didn't have rights here or there, or had rights and then didn't, doesn't really matter, because Integrated, your client, agreed to pay damages in the event that the equipment could not be returned, or and VMC breached the agreement, the forbearance agreement.
well, three responses to that, Judge Roscoe. First of all, it is not true that Integrated agreed to pay if VMC defaulted. What the agreement says, Your Honor, now this is really key. The agreement says that within 10 days after demand by Sovereign and VMC had defaulted, then the property would be returned. And that is significant here, because the demand didn't occur until way down the road. Sovereign sits on its rights for several months after the default, during which time, remember, if Sovereign had acted promptly when the default occurred, it still had a secured position. At that point, it could have asked for return, and Integrated would have been obligated. But it didn't do it then. It didn't make the demand in February, when now things have changed radically because Integrated has spent another $350,000. It didn't make the demand until 9 months later. So now, what does that mean? Now, the contract says two things. It says that in that event, Integrated will satisfy the forbearance conditions. And then the very next sentence says, if it doesn't satisfy the forbearance conditions, it will pay damages. It does not say it will pay the amount of money that would have been due by VMC.
Well,
and so that's where I take...
Mr. Cohen, it does, forgive me, it says, and I'm leaving out the beginning, but it says, failure to satisfy the forbearance conditions shall result in action being filed, and so on and so on. And then it says, the monetary damages resulting from Integrated Machinery's failure to satisfy the forbearance conditions.
Right, Your Honor. But
Okay.
what are the monetary damages resulting from Integrated Machinery's failure to pay the forbearance conditions? Consider this, Your Honor. What if Integrated had not been the buyer at the sale? I mean, what we know here is that Merrill Lynch is an independent player. And by the time, actually, it's Bank of America's successor, but whatever. There's a legitimate lender there, and it wants to be protected. So it wasn't going to, the situation was never going to be that Merrill Lynch was just going to sit by and not allow this property to be sold. So Merrill Lynch was going to hold a sale. If someone else had bought the property, then what happens? The buyer carts it away. Now is Integrated liable? It doesn't seem, it doesn't, and even more than that one, Your Honor. What happened, what if Integrated had done what Sovereign says it was supposed to do? What if Integrated had turned the equipment over to Sovereign? Sovereign couldn't keep it. Sovereign had no right to possess it, had no right to use it. It would either have had to turn it back over to Integrated, which would have been rather pointless, or Integrated's lender, Republic Bank AZ, would have had the right to come and swoop in and take it away. The problem is that Integrated let things happen, or not Integrated, Sovereign let things happen by not protecting itself in the first instance, then it entered into an agreement and didn't protect itself, and then things changed so that the consideration failed. There's no longer forbearance.
Let me raise, I think I'm echoing Judge Orozco, but let me put it in slightly different terms. What causes me concern here, having really read this really closely, is I perceive that your argument is that there is essentially a condition precedent incorporated into the agreement that Sovereign Bank had to have a possessory right to the equipment under Article 9 of the UCC. And so when it lost that possessory right, then it could not pursue Integrated Machinery under the forbearance agreement. But I don't see that condition, that language in here, and that's where I'm struggling.
Well, and Your Honor, it certainly could be more clear, but this is the bank's agreement. Sovereign didn't, or Integrated didn't draft this agreement, but the same comment holds true with respect to Judge Orozco's statement that Integrated is in the position of a guarantor. It doesn't say that either. And remember what's happening here. It gets worse because the way that Integrated, I'm sorry, I keep doing this, the way that Sovereign is interpreting this, the obligation to pay damages is both prospective and retrospective. Now, why is that? Where does it say that? That for those 9 months when Integrated is using the machinery and Sovereign hasn't even made demand, over half of the forbearance period payment had matured. Something like $65,000 of the total had matured during the period when no one had asked Integrated for possession. And yet the way this is being interpreted, Sovereign could wait till the day before the period ends and say, oh yeah, by the way, Integrated, you owe us $120,000. That can't be the deal. It's not the deal. It doesn't say that. What it says is, and this is really key, and I don't want to belabor it, I'm going to run out of time, but what it says is that Integrated will pay monetary damages. And what are the monetary damages for its failure to turn over the equipment? Well, the monetary damages, this goes back to Judge Anderson's point, there was consideration for a 3-month period. That's the only period during which Integrated received anything. And we've provided 2 alternate calculations of damages. If you just look at the payments that Sovereign would have received during that 3-month period, it's $15,000. If you look at the rental proceeds, it's $9,000. But at the end of that 3-month period, something changes, and it is odd to look at it because Integrated is both the party in the forbearance agreement and the purchaser. But I think if we separate those 2 hats and look at it as though the purchaser were someone else, the answer is has to be that Integrated had no continuing obligation to make forbearance period payments after it paid the $350,000 to Merrill Lynch to own the collateral. It is really no different than if, Joe's Equipment Manufacturing Company had walked into the UCC sale and said, I'll pay the $350,000. I'll pay $360,000.
I quite frankly, under that scenario, I think Integrated would still be on the hook. Quite frankly, they agreed that if the equipment wasn't turned over, that they would pay damages.
But
It has nothing to do with what the with the Merrill Lynch sale. I think if Joe Farmer had come off the street and offered $360,000, I still think that Integrated would be on the hook for damages.
And Judge Roscoe, I respect that, but what is missing in that is the doctrine of failure of consideration, and that
consideration, because at the time the consideration is looked at the time that the contract is made, and at the time that the contract is made, the consideration is the fact that they're able to continue to use this equipment. That's the consideration.
Under a doctrine under the doctrine of lack of consideration, yes. Under the doctrine of failure of consideration, no. These are two different and independent doctrines. The Arizona courts have recognized that consideration, even though valid at the beginning, can fail based upon subsequent events.
But isn't that, yes, you're right, the courts have recognized that doctrine. But in large part, it's based on an allocation of risk. And here, for example, the Merrill Lynch security interest was reflected in a UCC1 financing statement that was properly filed with the Secretary of State that covered after acquired property. And so Integrated Machinery could have searched the records for the prior financing statement, realized that there was a risk here, and protected itself. I mean, yes, there can be a failure of consideration, but isn't this a real problem, is that there's a failure of diligence here? Not
yes,
so much,
on the part of Sovereign.
but also on the part of Integrated.
Why
entering into an agreement that was stated in a way that does not appear to allow for what happened here.
But, Your Honor,
should they, Integrated Machinery, fail to return possession within 10 days from receipt of a written demand or request, then Integrated Machinery shall become obligated to satisfy the forbearance conditions set forth herein, and et cetera. I mean, that's pretty unequivocal.
et cetera, that's important, Your Honor, because then it goes on to say, in that event, it will pay the monetary damages, and there were no monetary damages. And the diligence here, the failure to exercise diligence, is Sovereign. Sovereign could have done a UCC search when it entered into the purchase money security interest with VMC. It could have sent a notification to Merrill Lynch, and it would have primed the Merrill Lynch security agreement.
That's right.
It could when Merrill Lynch sent notices of its sale to anyone who was registered in the name of VMC, that means Sovereign got a copy of that sale notice. Sovereign could have bought the collateral. Sovereign had the opportunity and the financial wherewithal to
You're saying
protect
there
itself.
are damages, but the damages are limited to the period in which Sovereign could have kept the...
Well, quite frankly, Your Honor, no. Our position is that consideration failed. But if there are damages, the damages have to be limited to the period within which consideration was flowing to Integrated, because otherwise Integrated is paying for nothing. And the one thing this contract does not say, and I'll challenge the courts to see it, is that Integrated agrees to guarantee performance by VMC. What it says is that Integrated will pay monetary damages flowing from its breach. So if there was a breach, the most it can be responsible for are the monetary damages during that period of time, even though no demand was made. And that's the problem, is that Sovereign didn't make the demand until later. So on
would
top
there
of
be-
everything.
So, I'm sorry, Mr. Cohen, and I'm going to have the bailiff give you a little bit of additional time here. But so, recognizing that that's not your principal argument, but if in fact there are damages, it would be only to the sale, the sale of the collateral?
That's correct,
Where the
Your Honor.
damages would cut off?
Correct, Your Honor. And there are the two alternate computations are either the rental income during that period or the amount of payments that otherwise would have come due. But otherwise, Sovereign is getting something for nothing. And I guess that's the end. At the end of the day, Sovereign lost its rights in this collateral. It cannot exercise forbearance. It's getting nothing, giving nothing to Integrated, and yet Integrated is supposed to pay Sovereign, even though for the right to use and possess its own property. I mean, consider how odd that is.
I think it's odd that your client would enter into an agreement like this, but the facts are what the facts are as they come to us. And so I just think that the fact of the matter is that they agreed to pay damages, and that's a whole different topic. I understand that, but they agreed to pay damages if the property was not returned, if the property wasn't returned. And
okay. Well, then let me try one more then, Your Honor. The damages run from the failure to return possession within 10 days from receipt of a written request. Why, under what theory do the damages go back? Why would the damages not go forward from the date of the receipt? How do you get from that the obligation to pay damages? How do you get from that to an obligation to pay the amount of money that had already accrued before Sovereign came out of its sleep and asked for return of the collateral?
And that's why I said the damages is a whole different topic on if damages are due, what they are.
Well, then, Your Honor, then I would ask the court to remand at minimum, to remand the case for a redetermination on damages, because the damages, the one thing that is absolutely clear is that Integrated did not agree to guarantee VMC's obligations, otherwise it would have said it. And Integrated did not agree to stand for the entire $129,000 in the event of any breach at any time. That's a penalty, and that can't have been the intention. So if the court is going to do anything, then the court needs to remand if the court is going to affirm, the court needs to remand the case for an evidentiary hearing on damages, because the theory of the lender is that, well, we just get to receive 100% because is not supported by anything in that agreement, and that was not what Integrated understood it was doing. If put it this way, if that was the intent, then why doesn't the contract say that? Why does it say monetary damages? If the contract meant Integrated will pay the balance of the forbearance payments starting from the date of the contract, good lawyers could have written that.
Mr.
Why does
Cohen,
it say damages?
With the bailiff's help,
I'm sorry.
that's okay. I think we've given you an additional 4 minutes. Now, you've got 1 minute and 14 seconds, so I just want to remind you of that. And then when Mr. Brophy gets to the podium, if you give him an additional 4 minutes as well, so we can true this up.
I appreciate that, Your Honor. Thank you.
Good morning, Joseph Brophy on behalf of Sovereign Bank. Integrated sort of started at the end of the case. I'd like to start at the beginning with the contract formation, but I do want to preface my remarks with what we said in the brief, which is, excuse me, this is not a UCC case. The forbearance agreement doesn't grant a security interest, and it doesn't reference Article 9, and Sovereign is not a secured creditor of Integrated. Integrated signed the forbearance agreement with Sovereign in November of 2010. At the time that contract was signed, Integrated had possession of certain equipment pursuant to a lease agreement with VMC. At the time the contract was signed, Sovereign had a judgment against VMC because it had defaulted under a lease agreement that entitled Sovereign to immediate possession of that equipment. Integrated signed the forbearance agreement because it did not want Sovereign to exercise its right to repossess the equipment, which it was going to do. Sovereign forbore its right to take the equipment in exchange for Integrated's promise to fulfill certain obligations in the event that VMC defaulted under the same forbearance agreement. And so there you have two sources of rights that are completely independent of the UCC. You have the Superior Court's order saying that Sovereign is entitled to possession of this equipment, and then you have the contractual rights that arise out of the forbearance agreement.
Well, I agree there's some consideration, but all Integrated seems to be promising to do is to pay damages if they don't turn over the equipment after it's asked. And why isn't the argument that's been made, why doesn't that make sense, that the only possible damages are how much you're out for whatever use you have of this for while you own it? And if you're not going to own it after 30 days when it's sold to someone else, how have you been damaged beyond your use of the equipment for 30 days?
There's two answers to that, Your Honor. The first one comes directly out of Section 7B of the contract, which says, should Integrated Machinery fail to return possession of the leased equipment within 10 days from receipt of written notice from Sovereign Bank, then Integrated shall become obligated to satisfy the forbearance conditions set forth herein. And in Section 4, forbearance conditions of forbearance is a defined term that includes a number of payments. So the concept of damages, as we all know, is to put Sovereign in the position it would have been in had the contract been performed, and that would be receiving all the forbearance condition payments that are set forth in Section 4. That's the first answer. The second is regarding this suggestion by Integrated that really what Sovereign is entitled to is the loss of use or the rental value. That's a concept from tort law, and I think it comes out of its Section 927 or 928 of the Restatement of Torts, and this is a contract case. I'm not aware of any cases in Arizona where a court has said, well, we're going to apply tort damages concept to a contract, particularly when the contract spells out exactly what type of payments were supposed to be made.
Let me ask, if Integrated had simply turned over the property, if your client had said, we want the property back now, okay, they turn it over, that would satisfy the forbearance agreement, correct?
Correct.
And so
they Integrated essentially had a choice. It isn't exactly phrased that way, but they had the option to keep the equipment, and if they did decide to keep the equipment, which they did, then they had to pay the forbearance conditions.
Right, but the forbearance condition says that you have to turn it over within X number of days of Sovereign making the request. So if you'd made the request, they would have had to just turn over the equipment, and then all your client has is the equipment that's subject to whatever liens or possessory interest someone else might have. And wouldn't they have at that point satisfied the forbearance agreement? If your client had sent out a notice saying, give us the equipment right now, and they give it to you, have they breached anything at that point?
No, because I don't think this is exactly the correct term, but there's they can elect their choice, their remedy, for lack of a better term. And they chose Section 7B, or rather chose not to exercise their right in Section 7A to return the equipment. But yes, to answer your question directly, this lawsuit probably doesn't happen if they just turn over the equipment, if they decide to go with Section 7A.
But your client never asked them to turn over the equipment.
Yes, they did. There's a, and I don't know if it's in the appendix, but it's definitely in the record. There was a letter sent, written demand.
Isn't that letter sent on November 21, 2011?
Yes, and I believe it's attached to the complaint, I think.
I think that's
So
correct.
what would your client have done then if they'd turned over the equipment 5 days later? Your client then isn't entitled to any further damages from Integrated? And your client now has the equipment.
Under those circumstances, had the equipment been turned over, I do not believe that Integrated would have been in breach of the forbearance agreement. But that's not the case that we have here. They had 10 days to turn it over, and they didn't.
Of course, they had bought it, to be fair, they had bought it from a senior Article 9 security holder.
That's correct, but that's a decision that they made. I'm not aware of any cases where you have a contract supported by valid consideration where somebody makes a promise and the other party decides not to exercise a right, and then because of something that the first party did unilaterally and without anything to do with the other party, all of a sudden they're excused from performance. And that's essentially the argument here. Because I purchased the lien rights of someone not party to the contract, I no longer have to do what I promised under the terms of the agreement. I'm not aware of any cases like that, and I don't think that that's a theory or an argument.
But even if we buy that argument, there's still the argument that all I agreed to do was pay damages, and your damages can't be for the full amount of the value since it was subject to others' interest in the equipment, or the full amount that you've asked for.
I'm not sure I understand.
And then that was a very confusing question.
Yeah.
But I'm just not making the complete link between a promise just to pay damages, and maybe I need to look, you're saying it's Section 4 that spells out what, in your view.
It's Section 7B and then Section 4. 7B says that if the equipment's not returned, then integrated will satisfy the forbearance conditions. And then Section 4 sets forth what exactly the forbearance conditions are, and there are certain payments that are supposed to be made.
But I think maybe the point here is that the forbearance conditions and the payments owed thereunder were predicated on Sovereign having a right to the equipment. It lost that right when Bank of America held the private sale sometime in February 2011. So when, months later in November, it issued its demand to Integrated to obtain the equipment, it didn't have any rights in anything. It had lost them to another creditor. So if we look at damages, one might wonder, how can it have been damaged when a senior superior creditor exercised that creditor's right to take the equipment and sell it, whether it's to third-party Integrated or Joe Blow?
Judge Norris, I think that I disagree with the premise of the question because of something that you actually said to Integrated.
Well, don't quote me. That's not reliable, so
well,
don't do that.
But essentially what Integrated's argument is, and you had it in the premise of your question, that this contract is subject to it's not expressed, it's an implied condition precedent that there be a security interest or a right to replevin or a right to immediate possession. Otherwise, Integrated is then discharged from its obligation to fulfill the forbearance conditions. In footnote 5 of the answering brief, this court held in the L. Harvey Concrete case that Arizona has adopted the general rule that conditions precedent are not favored in the law and that courts are not inclined to construe a contractual provision as a condition precedent unless such construction is plainly and unambiguously required by the language of the contract. So if Integrated is going to take this position that the right to immediate possession is a condition precedent to its obligation to perform the forbearance conditions, then they have to be able to point to where in the contract the language plainly and unambiguously says that. And that language doesn't exist. And that's really the flaw in their argument. And if I can sort of shift gears a little bit from that, because we have a binding contract that's supported by valid consideration, Integrated has to come up with a legal theory that would discharge it from its contractual obligations, and that's where this failure of consideration argument comes in. And the essence of this argument is, remember, the forbearance agreement is November of 2010, and then 3 months later, you have the purchase of the lien rights in February of 2011. And so what Integrated is saying is Sovereign no longer has any rights to forbear, and so consideration fails and Integrated is discharged from its contractual obligations. And again, this is the way I phrased it earlier is, because I purchased somebody else's lien rights, I no longer have to do what I promised. There's no support for this in Article 9. In the two sections that they've cited, I believe it's Section 9610 and 9617, you're not going to find anything in those sections that says this can discharge you from a contractual obligation, particularly one that isn't even a security agreement. And more significantly, if you look at all the cases that are cited in the briefing, there's not one on either side where there's a case like this where you have a case supported by, or a contract supported by valid consideration, and then somewhere a few months down the line, one of the parties deems that performance, unilaterally deems that performance worthless, and then says, I can just walk away from the contract. An example of failure of consideration, the way it works properly is Judge Norris and I enter into an agreement for the sale of property. She sells it to me, and then 3 weeks later, I find out that she never had title to the property. So there was never an exchange of value, even though there was, we had an exchange of promises, and more often than not, that constitutes consideration. But she never actually gave me anything from the beginning. That's not the argument that's being made here. Integrated said, I believe it was in response to your question, that at the beginning of the contract, when the contract was formed, Sovereign absolutely had the right to take the equipment, and it didn't do so. And so this concept of performance subsequently becoming worthless, even though it wasn't worthless at the time of contract formation, is not recognized. It's not a recognized legal theory, and if you read the answering brief, there's quite a number of courts that have actually rejected it.
What about the difference between failure of consideration, which is what you've just talked about, and well, I guess failure of consideration and lack of consideration. Failure of consideration. Where something happens down the road.
Failure of consideration is where lack of consideration. Let me just start there. Would be where there's no exchange. So if I just give you this pen, that's lack of consideration. It's a gift. Failure of consideration is where I say to you, I promise to give you this pen if you promise to give me $1. And so we exchange promises. So on paper, we have consideration. But then we find out that Mr. Cohen actually owns the pen, and so I never actually gave you anything that I had a right to give you.
Oh, there was no. So you had
there's no
right
exchange. Exactly. I shouldn't say there's no exchange. There's an exchange of promises, but there's no exchange of value that ever occurred. That's not the case in this case. There was an exchange of value. Sovereign had a right to possession that it was prepared to exercise, and it decided not to do that in reliance on promises that Integrated made.
But I think there can also be a failure of consideration on parties to a contract by external forces. Your example, I sell you property, and we all assume that let's say I do have title, I sell you property. But it turns out that unbeknownst to all of us, a city is getting ready to condemn it or to exercise eminent domain. So it turns out I don't really have it. Somehow we were all asleep at the switch. We didn't know this was going on. So there's a failure of consideration. I haven't in any way tried to cheat or to deprive you of something, but an external force has operated on our deal to eliminate that consideration. Isn't that what they're really trying to argue here? And the third party here would be Merrill Lynch or Bank of America.
It depends on, in your hypothetical, it depends on when that was the case. So if at the time we enter into the contract, the property has already been condemned.
Or let's say it hasn't been, but you're buying something thinking, that may not be a very good example, but I think you're with me on kind of the broader problem, which is we enter into an agreement, we have some assumptions, we've allocated risks, and all of a sudden, through an external force, the risk allocation has evaporated.
I guess my response to that, and I should let you answer, but my response to
No,
that.
I'd have her answer.
would be, you knew of that risk before you entered into the contract. You knew that Merrill Lynch was out there. And I'm assuming that everybody knew that Merrill Lynch was out there as a senior creditor. Is that correct?
Merrill Lynch has, from my understanding, a first position security interest. Under the terms of the contract, I don't really think that matters to Sovereign. That's really an issue for Integrated the purchase of lien rights from Merrill Lynch is something they decided to do. I don't see how.
I guess what I'm saying is at the time that the forbearance agreement was entered into, Merrill Lynch was out there as the senior creditor, or as a secured creditor. And so it wasn't something that was unexpected. You knew because they had noticed, they had UCC agreement, there was notice out there to the public that there was that they were a secured creditor and had security over this. That's not something that was unexpected. They knew, everybody knew going into this that Merrill Lynch was out there.
Everybody would have at a minimum constructive notice.
Would have constructive notice that that was out there. So it wasn't like, after you entered into this agreement, the city council decided to foreclose on your property or condemn your property. Is that what the difference is between this case and the situation that Judge Norris?
If you're talking about allocation of risk, I believe that would have bearing on it, the fact that this was a matter of public record, that Merrill Lynch was out there. But if you are talking about things, which is what Integrated is talking about something subsequently happening, it doesn't matter. For purposes of consideration, it matters, was value exchanged at the time of contract formation? And if it was, it really doesn't matter what happens after that.
Why doesn't the fact that the only thing that you would be turning over as part of this forbearance agreement is an asset that somebody else has an interest in that they can exercise in 1 month or 3 months? Doesn't that go to the consideration for this forbearance agreement? It seems like all they're forbearing is, okay, we're going to turn it over to you and you have it for a month until someone else takes it over, particularly if everyone is aware that this interest is out there.
Well, the argument that Integrated is making is that that Sovereign is a secured creditor of VMC, and if we're going to go down that road and buy that Article 9 applies to this, there's actually, not only is there nothing in the Article 9 that prohibits a junior creditor like Sovereign from foreclosing on its collateral, it's either Section 910 or Section 9610 or 9609, it's comment 5. It says it right in there that you can foreclose on your collateral even if you're a junior creditor. So there was nothing.
Damages would be less if you foreclose on it, and the only interest you're going to get in it is secondary to someone else's, to Bank of America's interest in the asset. Then you've only been damaged to the extent that that there's value beyond what Bank of America owns in it.
Well, I mean, that's I don't know the answer to that, because it would depend on the timing of VMC's default to Bank of America or Merrill Lynch. If they're not in default at the time the foreclosure takes place, nothing stops that junior creditor from liquidating the collateral. Remember, for the senior creditor to be entitled to those monies, there has to be a default. Otherwise, they're not entitled to they're not allowed to tie up the collateral for the junior creditors for a non-defaulting debtor. Does that make sense?
I think I
Okay.
get your point. And if I could, just one other question. The suggestion was made that the way you're reading the forbearance agreement turns it into a guarantee, turns Integrated into a guarantor without really any language saying you are a guarantor. What's your response to that?
Does it use the magic word guarantor? No, but I mean, is it a guarantee? Yes, it is. What is a guarantee? Somebody that is sort of the secondary obligor. If the primary obligor, VMC, defaults, then, I'm reading directly from Section 7B, then Integrated Machinery shall become obligated to satisfy the forbearance conditions set forth herein. And again, forbearance conditions is a defined term which is defined in Section 4. So yes, it is a guarantee. There's nothing that says that a guarantee has to use the word guarantee. That's perfectly acceptable language to create ones.
And the language in Section 4 that they are guaranteeing, what, do you have that in front of you?
I do. Section 4 starts off, it has a preamble that says, and it's titled Conditions of Forbearance, and it says, the following conditions shall constitute forbearance conditions, the satisfaction of each and every one of which during the forbearance period shall be a condition of Sovereign Bank's agreement to forbear as set forth in paragraph 3 of this agreement. And then all the subparts of section 4 spell out payments that are going to be made. And if you look, it's on,
Yeah, I have it here.
okay, page 5 and 6 of our answering brief. Unless anybody has any questions, actually, I think I've addressed everything that I wanted to.
Good.
Thank you, Mr. Brophy.
Okay, thank
Sir?
you.
Thank you, Your Honor. I want to be quick. First of all, the last thing that Mr. Brophy said is the answer to Judge Roscoe's question. There is a condition precedent because they're conditions. Conditions are mutual in that case. But I really want to talk about damages. And Judge Catani asked the question, what would have happened had Integrated turned over the equipment? Well, if Integrated had turned over the equipment when the demand was made, which remember is 9 months into the deal, then that would have been the end of the lawsuit. No lawsuit is filed. But what would Sovereign have had? Sovereign could not have kept the equipment. It didn't own the equipment. Didn't have a right to possess it. Didn't have a right to use it. The equipment was owned by Integrated. It would have had to give it back to Integrated.
Why?
Because
I'm
it
not
was
following
Integrated.
that.
Integrated was the true owner of the equipment. How can you have a situation where the true owner and the true owner's lender are not allowed to use, possess, and own their own equipment?
But couldn't you have it based on the language of 7B that says after demand, you return it? I know they had become the owner in the sense they bought it at the private sale from Bank of America, but they,
But that gets to the issue of damages, Your Honor.
okay.
And because it's fascinating. We were accused in the briefs of not quoting the entire paragraph, and yet twice counsel has partially quoted and left out the important language. Listen to what it says. Should Integrated Machinery fail to return possession of the leased equipment within 10 days from receipt of a written request from Sovereign Bank to return possession of the leased equipment, then Integrated Machinery shall become obligated to satisfy the forbearance conditions set forth here. And that's where he stopped. But that leaves out the important language. Failure to satisfy the forbearance conditions shall result in an action being filed against Integrated Machinery for breach of this agreement. The monetary damages resulting from Integrated Machinery's failure to satisfy the forbearance conditions, including but not limited to those set forth in paragraph 4B. It is not a guarantee. It is an agreement to pay damages. And that is the key. That is the key here, that it all goes back to damages. And the damages can't be the forbearance because there was no obligation to pay the forbearance conditions. By Mr. Brophy's own statement, there was an option. You could have turned it over or you could have paid the forbearance conditions. And since if you had turned it over, you were turning over equipment that was subject to a prior lien in favor of Republic Bank AZ, that equipment had no value in Sovereign's hands. Therefore, there is no damages, or the damages are limited to the 3 months.
We have a third argument, so we're going to have to break here in a moment, but that's okay, no. But let me ask you a question, because I thank you for hammering on the point. I now understand it a little bit better, so thank you.
Sorry.
No, I appreciate it for my own edification. Recognizing the distinction you draw between, on the damages, the language. But if I read the entire sentence, it goes on to say, including but not limited to those set forth in paragraphs 4D and 4I.
Through.
Through 4I.
Excuse me, 4D through 4I. Can't one then say that damages are coterminous with the monies owed under 4D through 4I?
Well, certainly not retrospectively, Your Honor.
They'd have to be
Because
prospective.
there's no relationship with what's happened has happened.
Okay.
And they didn't make the demand. At most, it's prospective, and even that, it doesn't make sense because the function of damages, counsel said, is to put the parties in the position they would have been in had there been performance. And had there been performance, the sovereign would have at most gotten temporary possession of property subject to a security interest in favor of a third party, and would have had obligation to turn it over to the true owner. So the damages, if any, are limited to that 3-month period that the court established, and we asked the court to either reverse the judgment in full or to affirm as to liability and remand for further proceedings on damages. And we didn't get to attorney's fees, but for the reasons we stated in the brief, Integrated should be the prevailing party since it prevailed on the main issue of replevin in any event. Thank you, Your Honor.
Thank you both for your argument and your briefing today. We'll take this matter under advisement and issue a decision in due course. Thank you very much.